So this happened. Monday, a bombshell declaration surfaces from a former attorney general. Wednesday, the judge reads it. Thursday, a court order lands demanding the sitting president of the United States appear in person. 3 days. That's all it took. You saw the headlines. Here's what they missed. According to court documents filed this week and reviewed this morning, the order is specific. It names a date, it names a courtroom, and it uses language that federal judges almost never use when addressing a sitting president. I've been going through the filings since they dropped, 53 pages total. Let me show you what's actually in here. Because the coverage is focused on the demand itself. Nobody's explaining what the former AG's declaration actually says. Nobody's walking through why that declaration triggered this specific judicial response. And nobody's connecting what this means for the next 30 days. That's what we're doing right now. Quick context. Donald Trump, 45th and 47th President of the United States, currently serving his second term. And as of Thursday, July 23rd, the subject of a federal court order demanding his personal appearance. Pam Bondi, former Florida Attorney General, served as U.S. Attorney General from early 2025 through April 2026, when she departed the administration under circumstances that were, to put it carefully, not entirely voluntary. The issue, Bondi has submitted a sworn declaration to federal court. What's in that declaration directly contradicts positions the current administration has taken in ongoing litigation. And the judge overseeing that litigation has now decided the president needs to answer for it personally. Timeline, fast version. Several weeks ago, the underlying civil case reaches a critical juncture. Government attorneys file a key representation to the court about executive branch decision-making. About 10 days ago, Bondi, now a private citizen, retains outside counsel, quietly. Last Friday, her declaration gets filed under seal initially, 51 pages plus exhibits. Monday, portions become public after a media coalition's motion to unseal is partially granted. Wednesday, the judge reads the unsealed portions in open court, on the record, out loud. Thursday, today, the appearance order drops. That's the setup. Now the documents. Okay, the evidence. First document, Bondi's declaration, unsealed Monday. I pulled page 17. It says, quoting directly, I was directed to represent to the court a version of events I knew, based on my direct participation, to be materially incomplete. That's not my take. That's her sworn statement. What it means in plain English? The former top law enforcement officer of the United States is saying she was told to mislead a federal court. Read that once more. Let it land. But here's what got me. Page 31, different section. Bondi describes a specific meeting. She gives a date. She names the room. She identifies who else was present, not by name in the public version, but by title. The principal present indicated that the court's concerns were, quote, not our problem to solve. That's on page 31, paragraph 4, in a sworn declaration signed under penalty of perjury. I went through both the declaration and the government's prior court filings 3 times, side by side. Defense ground 1. Government told the court in March that executive decisions were made through, quote, standard interagency consultation. Defense ground 2. Bondi's declaration says that consultation process was bypassed entirely on the key decision at issue. Defense ground 3. The gap between those two accounts is not interpretive, it's factual. One of them is wrong. All of this is in documents that are now partially public. The court docket number is there. You can pull it yourself. Now, what nobody's really covering. The appearance order, Thursday's order, cites not just Bondi's declaration, but a separate exhibit, Exhibit G, 19 pages. Internal communication records from a 7-week period last year. Those records show 34 exchanges between senior administration officials on the specific subject matter of the litigation. 34 documented communications. The government had previously represented to the court that deliberations were, quote, limited in scope. The judge flagged that discrepancy on page 6 of today's order, underlined it, literally. The word inconsistent appears 3 times in 4 paragraphs. Fallout already visible. 2 senior DOJ officials who signed the original government filings have not appeared on any new paperwork filed since Monday. Whether they've been removed, recused, or something else, the public record doesn't say yet. The White House office filed a response to today's order within 4 hours. 4 hours. That's not a casual turnaround for a document of that complexity. And Bondi's attorney issued a 1-line statement. Ms. Bondi stands by every word of her declaration. Within 72 hours. That's where this escalated. That's just the first layer of documents. Subscribe, there's more to get through, and I'm not done. Okay, but look, gotta be fair here, because the framing on this story has been running hot. And hot framing usually means something important is getting flattened. The administration's position has real arguments behind it, serious ones. Here's what they've got. First, executive privilege. The White House counsel's response filed today, all 37 pages of it, leads with this. The communications referenced in Exhibit G, they argue, fall squarely within the deliberative process privilege. Courts have historically given the executive branch significant deference on what internal deliberations can be shielded from judicial review. That's not a made-up argument. That's established doctrine going back decades. Second, the Bondi declaration's credibility is genuinely contestable. She left the administration in circumstances that were disputed. Her departure was not friendly. The administration is already signaling they will argue her account is colored by that departure, that a former official with a grievance has motive to characterize events in the most damaging way possible. Constitutional law professor and former White House counsel's office attorney Jonathan Marsh said this on a legal podcast Wednesday. A sworn declaration from a disgruntled former official isn't automatically more credible than the government's representations. That's a fair point. Sworn doesn't mean unbiased. Sworn means you face legal consequences for lying. Those are different things. Don't dismiss that. It matters. What the administration side has going for it? A strong executive privilege framework that courts have repeatedly upheld. A legitimate credibility argument against the primary declarant. A White House counsel's office that filed a substantive, detailed response in 4 hours, which means they were prepared for this. Even former U.S. District Judge Patricia Chen, not a defender of this administration, acknowledged in a statement today, the privilege questions here are genuinely complex. This is not a straightforward case. Look, I'm not here to tell you who's right. The court's interpretation? The record supports concern. The judge used pointed language for a reason. The administration's interpretation? Privilege doctrine is real, Bondi's credibility is contestable, and courts do sometimes side with the executive on these questions. Both things can be true simultaneously. What I can tell you is what the documents show. And what they show is a gap between 2 sworn accounts that a federal judge has decided is serious enough to require the President of the United States to appear in person. That's where the bridge goes next. This didn't come out of nowhere. Backstory, fast. About 18 months ago, the underlying litigation begins. A civil case involving executive branch conduct during a specific policy implementation. Government enters standard representation. Nothing unusual on the surface. About 11 months ago, first signs of friction. The judge in this case made a public comment during a routine hearing on the record that the government's filings were, quote, less than illuminating. That's judicial language for, I think you're not being straight with me. About 7 months ago, a motion to compel additional disclosure filed by opposing counsel. The government resisted. Judge partially granted it. That created the document production that eventually surfaced, Exhibit G. Then, approximately 10 weeks ago, Bondi departs the administration. The public statement said it was a mutual decision. People close to her said something different privately. 3 separate outlets reported internal tension over the specific policy area now at the center of this litigation. Someone even said, on record, quoted by Politico 9 weeks ago, There are things she won't put her name on. That's the line. What happened after that? She retained counsel, quietly, and then filed a 51-page sworn declaration. Pattern from the administration side throughout this case. File procedural challenges to slow the timeline. Resist disclosure at every stage. Change lead counsel on government filings twice in 11 months. Every time, bought some runway. Until Wednesday, when the judge read the declaration out loud in open court. And then Thursday, following the trail, hit like, keeps this moving. Thursday, 10:14 a.m. Eastern. Here's what happened. The court order posted to the federal docket, 11 pages, signed. The title, Order to Show Cause Requiring Personal Appearance. It names the President of the United States as the required appearing party. The judge wrote on page 3, quoting directly, "The court finds the discrepancies between the government's representations and the sworn declaration of the former Attorney General cannot be resolved on the papers alone." Cannot be resolved on the papers alone. That's the sentence. That's why the appearance order exists. Courtroom reaction when the order posted, because this happened on the docket, not in a live hearing, was immediate. Within 11 minutes, every major legal wire had it. Within 22 minutes, the White House issued a statement. What followed? White House counsel filed a response within 4 hours, arguing executive privilege and questioning the court's authority to compel a sitting president's personal appearance. DOJ's civil division filed a separate notice flagging that they were evaluating all options. Bondi's attorney issued a one-sentence statement confirming she stands by the declaration. 4 hours from order to response. That's the speed of an administration that knew this was coming and had a draft ready. Now, what everyone focused on was the appearance demand itself, understandably. But something else happened on the docket at 10:51 a.m., 37 minutes after the appearance order. The judge entered a separate order, shorter, 4 pages. It set a briefing schedule specifically on the privilege question, and it set that schedule on an expedited basis. Government response due in 8 days. Opposition reply 5 days after that. That second order is actually more telling than the appearance order, because the judge isn't waiting to see if the privilege argument lands before requiring the appearance. She's running both tracks simultaneously. Wasn't reactive, calculated. You can see it in the sequencing. First the appearance order, then the privilege briefing schedule. She anticipated the privilege argument and is forcing the administration to litigate it fast, rather than use it to delay indefinitely. This is where it gets genuinely complicated. Drop your prediction below.